Good evening, friends. After I would say quite a lot of time, we have brought on board Dr. Aditya Sondhi, a senior advocate. And since he was primarily initially practicing in the High Court, and now he's also shifted to the Supreme Court, we thought that a lawyer who has actually seen the facets of High Court as well as Supreme Court, from him, if we can come to know what are the scopes, etc., and what is the difference. And before we take him forward over the session, Dr. Sondhi, we'll be taking discussions in respect of jurisdictional differences between the High Court and Supreme Court, procedural variations, that is filing, appearances, etc., the nature of practice. Now, since we are discussing about this, judgment is also the role of senior advocates in different courts. Then challenges and opportunities in practicing in both levels. Because they say higher you go, maybe it's a profession or vis-a-vis jurisdiction, it gets more and more tapered down. Not taking much time, I will request Mr. Sondhi to take over.
Thank you, Vikasji, and it's nice to be back on your platform after quite a few years. I had spoken earlier on the law of precedents, and I'm glad to now be speaking to colleagues and friends on this topic, which is a comparison of the practice in the Supreme Court and in the High Court. There are a couple of prefatory statements that I want to make before I begin. One is that I did not commence my practice in the Supreme Court, but shifted to the Supreme Court, as you said, about 3 years ago. Though since 2006, I have been appearing in the Supreme Court as an arguing counsel. The other caveat that I want to place is that I have never been an advocate on record. And therefore, my perspective will be really that of an arguing counsel and not of a filing counsel. And the unique filing requirements of the Supreme Court would perhaps be dealt with better by someone who has experience as an advocate of record, on record. With that said, I'm particularly delighted to be speaking to all of you today because today is in fact 26 years since I enrolled as an advocate. 22nd March 1999 is when we got our gown. Though ours was a peculiar time where we enrolled a year earlier in 1998, but had to undergo an apprenticeship system, which was then done away with because of an order of the Supreme Court. So I don't know if this makes it more auspicious today. Surely Vikas was not aware of this. Friends, I'll begin by first giving you some reflections on what I think are the attributes of practice before the Supreme Court, which are seemingly unique to the Supreme Court. I must be very clear to you upfront that I do not belong to the school of thought that believes that one is better than the other, or that simply because one is practicing in the Supreme Court, one has some moral high ground or a right to claim, some sort of superiority in the profession. That's certainly not true. Some of the best counsel I've seen are trial lawyers who are happy and content being trial lawyers. And therefore, this is more to give you a feel of the, shall we say, the nuances of practice as between the High Court and the Supreme Court, so as to give some of you, especially younger counsel, a flavor of it, so as to help you decide which is more suited to you and when, if at all, you must consider moving to the Supreme Court. It struck me that the practice before the Supreme Court in some ways is, if I may call it, a one-point advocacy. When I say one-point advocacy, what I mean is that more or less in most matters before the Supreme Court, and most certainly in fresh matters, what you call miscellaneous matters that list as fresh cases in SLPs before the Supreme Court, it's really one point that can make the difference. And it is threading the eye of a needle so as to find that one point. But that one point is central to your approach to cases in the Supreme Court, in contradistinction to the High Court, I would say, where you have a greater amount of elbow room to build your case even at an admission stage. You may not make your best point first, you may make it later, or there may be one of 3 points that appeal to a court, but by and large, you would be able to justify issuance of notice at least in a writ petition before a High Court if you have an arguable point. You may or may not get an interim order, that's a different matter. But in the Supreme Court, owing to two factors, one is, of course, the unique jurisdiction that the Supreme Court exercises under Article 136, which is special leave jurisdiction, where really an SLP is not an appeal against an order of the High Court or of a tribunal or of a trial court. It is a petition to grant leave. And that leave, as you all well know, is granted on the discretion of the bench if there is a fit case that fits the parameters of Article 136. And therefore, it is that one point very often that helps you get that foot in the door to convince a bench as to whether indeed it's a fit case for notice to be issued and ultimately for leave to be granted to hear the case as a regular appeal. Now, there lies the challenge. One may think it's simple or simpler than the High Court because you're down to one point as opposed to laboring on others. But in my limited experience, it's in fact harder to come down to that one point because it requires you to sieve through the material of the High Court, many times 2 rounds on account of an intra-court appeal, or 2 or more rounds if these are special leave petitions that are going up from orders passed by the trial court. And to sift through the pleadings, the documentary evidence, the oral evidence where it applies to a suit or a criminal proceeding, the questions of law that arise, and ultimately basis your own experience and instinct, and perhaps to an extent basis your reading of the bench that you're before, to decide which is that one point that you ought to play first. And many times that is the call we make as senior counsel. And Vikas had mentioned that. That's perhaps where our role becomes even sharper, which is for us to be able to put our finger on the pulse and say that this is the one point which is likely to appeal to the court. For that, one's preparation, in a sense, has to be far more exhaustive because you have to be ready beyond the final hearing. And to me, this is the one key factor which perhaps sometimes is missed, that your preparation for a special leave petition coming up for admission as a fresh matter is actually your preparation for final hearing. And only if you approach it as such would you be able to possibly lay your finger on that one point or be able to anticipate the point that will appeal to the court, or more so, as we often are surprised in court, to react to the doubt or the question that the court has. You see, you may have read your file and prepared it from your perspective with your emphasis on one dimension of the case, but the court, after reading the papers, and more particularly the impugned orders, may actually be impressed or be inquisitive about a point that you didn't think was the most important. But often, and I've always said that advocacy is response to questions. Your time frame in the Supreme Court, and this is the other point, is a limited time frame, especially in SLPs and fresh matters. It's a matter of minutes, often a matter of seconds. And unless you're able to suitably respond to that question that the bench has for you, you're a non-starter. And you may have a good case. You may have a good case even on law, but Article 136, friends, unlike 226, as I said, is a discretionary remedy, a far more discretionary remedy whether to grant leave at all. And in many cases, you find that the Supreme Court says, yes, you may have a case, but not a fit case enough for 136, leaving a question of law open or dismissing an SLP. And please remember, friends, that the dismissal of an SLP is not necessarily a confirmation of the order of the High Court or of the trial court. So it's not that the Supreme Court is really laying down a law by dismissing an SLP in limine. This takes you to other questions that the Supreme Court has decided in Khode's case and others as to when there is merger between the High Court and the Supreme Court orders, when a review can lie after dismissal. I'm not digressing into that. But suffice to say that the dismissal of an SLP in limine is really saying that you have no right to be granted leave. And there ends the matter. It's not then an affirmative statement on the law by the Supreme Court. And in an identical situation, a different SLP before a different bench, or possibly on slightly different facts or equity, could be entertained by the Supreme Court and have a completely different result. So this, folks, to me is really the crux of the difference. And it is upon this that we must all dwell when it comes to our approach to cases in the Supreme Court. As I said, one factor is the 136 jurisdiction in itself. The other is the conscious or maybe some subconscious approach of the court to also filter out cases. As you know, we are perpetually facing criticism in our system for delays and backlogs and so on. And what better way than to reduce backlog than to simply filter out cases at the entry level. And that's why you find that by and large, in every court where there are fresh SLPs listed on a Monday or a Friday, say there are 20 fresh matters, you will not find notice being issued in more than, say, 3 or 4. Or in some benches that are liberal, that number may go slightly higher. But even there, I would think it's safe to say that more than 50% at least of fresh matters would be rejected at the outset. And this in a way also becomes a form of case management. And one must be conscious of these realities. One cannot expect as a matter of right the Supreme Court to entertain every SLP for every point that arises. You see, even in a writ petition, you can't expect that in a high court. If you're not able to show, say, locus standi or an error of jurisdiction, depending on the nature of the writ that is moved, a high court may very well reject the petition at the outset. But the position is different when it comes to statutory appeals. When there is a regular first appeal under Section 96 of the CPC, or an appeal under the CRPC or under the BNSS, one could, I think, there reasonably expect that those appeals should be admitted for hearing, because courts do take a second look at the evidence. But in the Supreme Court, that's not a legitimate expectation to carry. In fact, my advice to any counsel appearing in an SLP would be to assume that the court would want to dismiss the SLP. Once you build in that assumption, I think by nature, you would want to work harder. This is not to discourage you. This is not to give you a shortcut to say, oh, look, anyway, the SLP is going to be dismissed. What difference does it make whether I prepare 110% or 60%? No, at least I don't belong to that school of thought. Whether the SLP is being dismissed with one word, dismissed, our effort must never fall short. But if you presume that the bench is not going to be impressed, even with a point that an AOR thinks is a strong point, I think it's on us then to work that much harder with that much more effort and cover all tracks so as to be ready to make your best point, to anticipate the question that the court will make, and then try and make out a case for notice. And I think this is something I have come to realize over the years before, by appearing in matters before the Supreme Court. I think one other aspect that needs to be mentioned here is the work ethic of judges in the Supreme Court. I'm not making comparisons here. You have excellent judges in the trial court, in the High Court, and in the Supreme Court, and one is not making a systemic comparison at all. But I think because of the sheer nature of the jurisdiction in the Supreme Court, the load that the court has to carry, and the requirement to be able to deal with serious constitutional and public law matters brings a different pressure upon the bench also. And one must be cognizant of that while practicing, because that in turn means that benches in the Supreme Court are often, by and large, fully read and prepared in cases. That may not always be the case in the High Court, and I'm not using this as some kind of a comment upon the role of the High Courts. It may not even be necessary, in my opinion, to be very honest, for benches in the High Court to have read every word of a matter. I know senior judges sometimes used to tell us, in a lighter vein, that we don't like to read the file because that can sometimes form a prejudice. And if a prejudice is formed, that limits the scope for advocacy. And some of the best judges I've known have really come to court with an open mind, and sometimes just looked at the file impromptu and decided whether to issue notice, grant stay, etc. And with experience, judges can easily do that. But with an SLP especially, the ball game is different in the Supreme Court. Because, as I said, if it's a one-point advocacy for us, in many ways for the Supreme Court also it's a one-point approach. It's not that the Supreme Court needs to find that one easy point to grant leave on. It's in fact the onus on the bench to see whether on totality it's a fit enough case to entertain as an SLP. And therefore, just as I said, that counsel need to work that much harder, I believe, in these matters, the bench also is required, and I have seen has that tendency to read files word by word, page to page. And one should not be surprised that when an SLP comes up in a criminal matter, for example, against concurrent conviction, a bench may ask you, what do you say about the statement given by PW6 at page 166? This happens. And that tells you that the court has read it not simply as a fresh matter prima facie, but on a totality of the evidence that has been led to see as to what likelihood that case would have to succeed in the long run. And if it's a case of concurrent findings, often civil matters, criminal matters, revenue matters, courts are going to be averse to issue notice. And if in the long run the appeal is anyway going to be dismissed, then what purpose is served in issuing notice? And that work ethic is something I think to be regarded with and to be fully acknowledged, that when you step into court, if the bench is fully ready and has fully read the brief, then there's really no excuse for us to be short on any front. And I think that is also a corresponding work ethic that counsel need to have in practicing before the Supreme Court, as I said, because of the sheer speed at which courts work. And I don't think enough credit or acknowledgement is given to this. Sometimes courts are too fast. You can barely even frame your submission, and the court is, well, if they're issuing notice, you're happy if you're the petitioner. But otherwise, it's an arm wrestle, and one has to be up for it. But this is something I don't think is acknowledged enough, because those who look at the system from the outside tend to look at it statistically, to say X number of cases pending, average duration per case, etc., etc. And I have somehow always found that granular and statistical approach slightly misleading. It's an important approach because it shows you a larger picture of where we are systemically, and one has to factor that in. I think in this era of technology, AI, and justice delivery being part of good governance, you cannot disregard the micro details of the system. There's no doubt. But at the same time, it doesn't necessarily portray the immediate or the accurate picture as to how courts approach cases. And this is where you need to see how Supreme Court also lists its cases. Of course, this is often dependent upon the discretion of the Chief Justice concerned. And if you look at the system now under Chief Justice Sanjeev Khanna, you have one regular hearing day, which is Thursdays, when old leave granted matters get listed in serial item 101 onwards, 20 matters per bench, and those are heard as regular hearing matters. On all other days, Mondays and Fridays, of course, are miscellaneous days. Tuesdays and Wednesdays, which are regarded as non-miscellaneous days, also have fresh matters listed. Bail matters are listed every day. And apart from the regular hearing matters, in a sense, one must treat all other matters as being the equivalent of miscellaneous petitions. Even if notice has been ordered in an SLP, It is not incumbent on the court to hear the matter fully by admitting it or granting leave and make a speaking order. An SLP after notice can also be dismissed in limine, as is often the case. So therefore, everything I've said in terms of your preparation and anticipation for a fresh SLP, in a sense, in my experience, would apply equally to after notice matters, because they may well meet the same fate. That is a comparison that one must make with the High Court, because what I've seen is when notice is issued in a writ petition, then it goes down, I think, generally a predictable trajectory, which is to say respondents will file objections, unless, of course, it's something that can be closed on a short point, like alternative remedy and so on. But otherwise, counters to be filed, rejoinders to be filed, pleadings to be completed. That's not mandatory in the Supreme Court. There are so many cases where courts have said you don't need a counter here. So that, friends, that again, I think keeps you on your toes when it comes to approaching matters in the Supreme Court. But it's important also, therefore, to look at the sort of pleading one makes in matters in the Supreme Court. And as I said, I've never been an AOR, but as a counsel, whenever I was appearing in cases in the Supreme Court, that's before my designation, I would try and involve myself in the drafting of the SLP so that I would be able to be in better control of the matter. And I think you will all agree with me that when you're drafting a petition, you're actually in best control of your case, because everything sits well. At least that's what we've learned. When you prepare a writ, somehow the best points are already with you. Whereas if you're reading a file, then you have to do it secondhand and still arrive at the same conclusion. But as an AOR, when one is preparing an SLP, or as a senior, if I am settling an SLP, one again must return to this paradigm that I had set out earlier, which is the workload, the speed, and the volume of the cases. Look, friends, I'm not only saying volume in terms of number of cases. I'm saying volume of material in each case. You see, in a Supreme Court, but naturally there is at least one additional round of litigation that has happened, at least one. And as a result, the volume of that SLP is bound to be larger. It's bound to contain more evidence, one more judgment, possibly some additional evidence that is often filed. And courts are required to read those papers many times the evening before. And as much as I said, courts come fully read, it's but natural that courts are going to read some parts more closely than the others. And we need to know as counsel as to what those parts are and try and project the best case in those parts. That is the one point advocacy that I was talking about. That one point that you think is crucially important must appear in your synopsis. It must appear in the questions of law that you frame, ideally as your first question of law, so that a bench that reads the synopsis and the question of law, I cannot personally obviously say as to how benches approach it. Each bench may have its own approach, but I would think that the impugned judgments are read, the synopsis is read, and possibly the questions of law framed are read, apart from all the other material. And if leave under 136 is really on larger questions of public law of constitutional importance and not in every case, then that question must scream out from the petition. It must be forthcoming. It's not something one must labor. And if you're able to crystallize it in the synopsis or in the questions, it stays with you. It stays with you as a counsel. That question is already clear, so that when you're arguing, subconsciously you already know what window you're fitting your case into. Many times I've seen cases being argued casually or lackadaisically, as if it's a court of original jurisdiction. That some particular document says this, or a particular witness has said this, etc. Look, all of that is the minutiae that has to fit into the larger question of law on which leave should be granted. Otherwise, even 50-50 cases, leave can be refused. Even in better cases than that, leave can be refused. And therefore, that onus, friends, is important to build into drafts that are filed before the court. Here, folks, I must also say that one must be aware of the axis of jurisdiction that the Supreme Court exercises. 136 I mentioned to you. Of course, there is 142, which is like the Brahmastra that the Supreme Court has, the power to do full justice in every case. And that can, of course, cut both ways. It's something you can avail of as a counsel in larger interest. It's something the court can often use and say, it's not a fit case for 142 because you have to have an above exceptional case for 142 to be exercised. And the greater you read and understand the parameters of 142, I think the better. Article 32, I think, is a not often enough used provision in the article simply because the Supreme Court does not entertain Article 32 petitions for the asking. Dr. Ambedkar had said that Article 32, the right to constitutional remedies, which is in itself a fundamental right, was the most powerful or important provision in the Constitution because it guaranteed the right to justice and constitutional remedies itself as a fundamental right. It's an exceptional article. But at the same time, 32 is not entertained by the court for the asking for multifarious reasons. I don't have time to go into that, except to say that if the Supreme Court feels that the issue that is brought before the court in a 32 is something that can be effectively thrashed out in the High Court, then parties are relegated. More often than not, 32 petitions, you are sent back to the High Court. The other is, of course, that you need to be able to show an ex facie violation of fundamental rights. If it's a public interest litigation, a much larger effect on the interests of the public, on the environment, on safety, etc., etc. In fact, I am appearing for the Delhi government in the MC Mehta matter, where the Supreme Court has issued one such direction, which is really an exercise of its powers under 32 read with 142, which was a unique and extraordinary direction, which was to pay sustenance allowance to all workers in Delhi at the time when the GRAP 4 restrictions were in place. And the Supreme Court found that if the restrictions were in place to regulate environmental pollution, as you know, the AQI in Delhi during those months jumps up to 300, 400 plus. But that does not mean that the rights of workers and their rights to receive fair wages for that period, at least in terms of sustenance, should be affected. And the Supreme Court therefore issued a direction to us as the government and other state governments to make available this sustenance allowance, and that is being paid from the building workers cess fund under the statute. Now, these sorts of far-reaching, unique directions, and as I said, I don't have time enough, but you know the realm of 32 read with 142, everything from sexual harassment at the workplace to environmental issues, to administrative reform, police reform, Prakash Singh, etc., etc. It's a long, long list. Are all orders, sometimes people have said in the nature of legislation even, that the Supreme Court has made. But at the same time, this is not a power that one can expect to be exercised in all cases. And here lies the difference again. And that is a call one must make as a counsel when a potential question arises as to whether to approach the court under 32 or 226. One would be well advised to see whether objectively the case fits the bill under 226. And if that is the case, to take it to the High Court in the first instance and not simply move the Supreme Court and have it dismissed. Of course, folks would say, so what if it's dismissed with liberty to move the High Court? Yes, that's true. But at the same time, I think the rejection of a 32 petition by the Supreme Court, even on a technicality such as this, has a psychological effect then on the High Court, saying that if the Supreme Court has chosen to reject it, perhaps it was not a fit enough case or a case pro bono publico. And one must keep that aspect also, I think, in mind. Practicing in the Supreme Court, I think on the sheer account of it being final, brings with it a certain pressure and uncertainty, which I think counsel have to be aware of on a day-to-day basis. And to me, this is a marked difference. In the High Court, you have a little bit of, or maybe a little more than a little bit of, shall we say, comfort that even if matters go amiss, you have at least one more shot at it. If it's a single judge, you may have a right of an appeal in a writ appeal or a letters patent appeal. And if it is not an appealable order intra-court, you have a shot under 136. It gives you some comfort that all is not lost. But with the Supreme Court, as you know, those dreaded words SLP dismissed mean the door is closed for you. Of course, you have a right of review, you have a right of a curative petition, but those, please don't ever treat those as very strong rights. A review in the Supreme Court is heard in chambers. It is not heard in the open court unless the court thinks it fit to hear it, as happened in the, for example, in the Bhopal case, the curative petition was heard. In the 377 judgment, the matter was heard in the open court. But those are exceptions. Review petitions get listed frequently before benches in chambers and are dismissed without even a hearing. And those are the rules of the Supreme Court. That is a unique facet of the rules in the Supreme Court. In the High Court, a review petition also comes up in the open court. And in a sense, you have another bite at the cherry to make your submissions orally. And a curative petition, friends, I think you're all too well aware of the very, very limited scope within which a curative can be fit. Of course, in the Delhi Metro case, the arbitration matter, you found that the Supreme Court in a curative petition had set aside the judgment of the High Court and ultimately set aside an arbitral award. But those are again rather extreme cases. By and large, curative petitions, you can forget about it. So if that is the case, that finality, the uncertainty as to whether your case fits the bill before a particular bench, I think is just par for the course. There's very little one can do about it. But as I said, the greater the pressure, the greater the uncertainty, the faster the bench, I think the greater the corresponding requirement for us to be thoroughly prepared in cases and to approach cases at their fullest. And there, friends, if you have an SLP in a criminal matter, especially, and I do a fair amount of criminal work, one can never gloss over even the minutest parts, be it from the FIR to the charge sheet, to the 161 statements, to the evidence of the witnesses, the evidence of the investigating officer, to the kind of cross-examination that has been done many times, that leaves a lot to be desired. One has to be fully prepped on that. Otherwise, you will be found wanting. You cannot expect that simply because it is a matter pertaining to liberty, that notice will be granted. That's not the case. Many times these SLPs are dismissed at the outset. Even statutory appeals. You see, this is a point I want to make. I mentioned letters patent in between, and I think one of the charming parts of practicing the Supreme Court is the exposure you get to cases from various high courts. That gives you a very different flavor of laws that prevail in states. And that for me has been a tremendously learning experience. I'm doing some cases relating to migration in Assam, cases from Telangana, where the old regime of the Nawabs has its own peculiar revenue law model, which is very different from any other state. And it's a long list. Alongside that, I think is the more diverse approaches that high courts take to cases and the peculiar high court acts as to when there is an intra-court appeal provided, when there is a letters patent appeal provided, when there is not. Those are also a part of the learning experience. One may have practiced in one or two high courts and be familiar with those, but that doesn't mean that those procedures apply pari materia in all high courts. And that becomes a very interesting part in many high courts. For example, bail petitions can go directly to the high court because of the concurrent jurisdiction. In Karnataka, where I began my practice and practiced for most of my career, that's not the case. That bail petitions always go to the sessions court and only come to the high court as a second round. So some of these nuances are interesting, but I think with that also comes the ability for one to be able to appear in other high courts and to be able to take up these interesting cases. But the diversity, friends, goes beyond that. I think the diversity is also of the type of matters that come to the court. And I mentioned statutory appeals to you. And this is interesting because you actually have statutory appeals provided for under many acts, the Companies Act 423, commercial laws, securities laws, etc., etc. It's a long list, even criminal legislation. Now, one would think that statutory appeals at least stand on a different footing from special leave petitions, and because they're an appeal, they're in a sense a right. Article 136 is only a right to seek leave. It's not an appeal in itself. Whereas a statutory appeal is a right of appeal. And one would like to think that an appeal, therefore, should justify notice at least. But please don't take that for granted. Courts do not entertain statutory appeals, that is the Supreme Court also, unless you're able to, in many ways, in my experience, fit the same 1-point test. And whether it's an appeal or an SLP, if you're able to show that standout point coupled with a miscarriage of justice, these are not academic questions courts decide. Only if you're able to do that are you able to get some relief in court. And therefore, even with this separate subset of statutory appeals, one, I think, must approach them in many ways like SLPs. One is the better with that preparation. I do enjoy in the Supreme Court the diversity also of benches and counsel. And I think this is another charming facet of the Supreme Court, because you see learned counsel from across the country who have their own unique approach, skill set and experience and exposure to many facets of practice. I think that is a rich learning experience which cannot be easily replicated in the High Court. You also have an interesting diversity of benches of learned judges who have been exposed to different streams of law. And I think that is also something to be said in favor of your learning in the Supreme Court. Often in the Supreme Court, you have retired High Court judges who have then returned to their practice. And they bring, I think, an interesting approach to cases also, because they've had a good look at both sides. And I personally enjoy observing them and learning from them. A very important part of the practice in the Supreme Court also, friends, is the scope for precedent. And as I said, I had spoken on the law of precedents at this platform some years ago. Your reliance on precedents in the Supreme Court in many ways is far less than in the High Court. That's because the Supreme Court often proceeds on first principle. And it's not that High Courts don't, but I think your comfort and your strength with first principles has to be stronger in the Supreme Court, because in an SLP, especially in discretionary jurisdiction, and that makes up a chunk of the jurisdiction, even if there is a judgment on the point, it may not necessarily be applicable to the SLP on those facts or be good enough to justify the entertainment of an SLP. So I think it cuts both ways. Regardless of binding precedent, your advocacy has to be, I think, more on first principle. The fluidity or the advantage is that the Supreme Court in many ways is less bound by its own precedents. And what I mean by that is that the Supreme Court has the facility to refer cases to larger benches, as often happens. And that is another charm of the practice, if I may, before the Supreme Court, which is larger matters of constitutional public law importance. I've had occasion to appear in the hijab case, for example. Of course, that was before 2 learned judges who differed and got referred to 3 judges. But I'm appearing in the matter relating to the power of the Speaker to disqualify members of the Legislative Assembly, etc. These are cases that go before constitution benches, larger benches, and therefore, in many ways, the law is up for grabs. You have 3 judge benches before the Supreme Court who may take a precedent of 2 judges as being not good enough law and are in a ready position to set aside that law if required. That advantage one doesn't have in the High Court, because in many ways, the law laid down by the Supreme Court under 141 remains binding on the High Court. And I think the approach to precedents in the Supreme Court itself, I think, is a very interesting aspect of the practice. As I've said in my talk earlier, I don't belong to the school of thought where one must clutter the court with case law. I think that's even more true in the Supreme Court, that until and unless there's really some gaping hole in the law, one must try and push through cases on first principles. But this, trends also means that one is engaged with the emerging trends in the law. And I appear in cases involving death penalty, for example, for the accused. And you'll be amazed to find how much jurisprudential progress the Supreme Court has made on death penalty jurisdiction, on that jurisprudence, to give far greater facility for the accused to be able to show reformative tendencies and to bring in other factors which would justify the court not to grant death, even despite the heinous nature of the offenses. And I think that the more emerging bail jurisprudence in the recent days, especially in UAPA, terror matters, in money laundering cases, these stand out because they are pro-state, more difficult to get bail, but you still find the Supreme Court carving out Article 21 exceptions and chipping away at those statutory restrictions so as to balance the rights of the accused and to give facility for bail to be granted where a trial is going to be delayed, etc., etc. So, folks, that becomes, I think, another important part of the practice in the Supreme Court. As I said, all of this, in contrast with the High Court, has really come to convince me that there is a different level of satisfaction in appearing before the High Court, because the scope to develop a case and to argue a case fully in many ways is greater in the High Court. And I want to make this point. Because even on days of regular hearing before the Supreme Court, because of the case having already gone through 2 or more rounds, the approach of the bench, and look, it's very difficult to expect courts to have an approach on 4 days of the week and a different approach on day 5. By and large, that's inbuilt. So that speed and that tendency to approach cases from that short point perspective is there even on regular hearing days. And one sees it. It's not that regular hearing matters necessarily go on for days. Some do, but by and large, they don't. They get closed quickly. But the satisfaction of arguing a case fully, in placing the facts, in developing the pleadings, in developing the questions of law, all of which will feed the case ultimately in the Supreme Court, is really from the High Court. And even now, when I get a chance, and that's the reason I'm back in Bangalore today, because we had a special sitting and there were some cases listed before the High Court, the satisfaction of arguing these cases in extenso before the High Court, I think, is an unmatched facet. And therefore, one must grab that with both hands. I want to please say, and I said this at the beginning, there's no hierarchy here. There's no saying one is better or worse. It's a personal choice. And please don't be so enamored by the Supreme Court so as to think that the High Court practice falls short. Certainly not. If you actually are able to enjoy the original jurisdiction of the High Court and writs, the original jurisdiction of the trial courts, though I'm not here to compare trial courts, but the charm of cross-examination and leading of evidence in trial courts is unmatched. You may get a slight flavor of it in an arbitration, but nothing like that in a live hearing in court. I think is something that's to the credit of our system, and therefore that is where, to me, the High Courts are really where you build the basis for a case in the Supreme Court. In many ways, friends, that's where you build the base for your practice. I have personally always believed that one must begin your practice in the trial court or in the High Court. I personally spent less time in the trial court and more in the High Court. But I do belong to that school of thought that you must work your way up. I moved to the Supreme Court 3 years ago, which is in my 40s. I know folks who have started in the Supreme Court. That's a choice they make. But I do personally believe that it is to your advantage if you have that body of work and that experience behind you in the trial courts and the High Courts, because then you approach the brief differently. This is coming back to my original point. When I said 1 point advocacy, that 1 point doesn't just come to you in your dreams. It comes to you from your instinct, and that instinct is developed in the original proceedings. If you've conducted trials, you've drafted plaints, you've argued cases, you've argued writs, you know what pleadings requirements there are in writ petitions, what the scope of a writ is, what is equity, what is a bar to jurisdiction, etc., etc., only then can you really look at an SLP or a case in the Supreme Court in its true essence. If not, you're reading it top down. You're reading it simply as a Supreme Court counsel, and that may sometimes be a bother because you're not getting to the pulse of the matter. How often have I appeared in cases where judges have said, yes, you may have a case, but what is the scope of Order 7, Rule 11? If it's an SLP that's gone up from there, and unless you've done enough trial work, you know the parameters of Order 7, Rule 11, which is that you only look at the plaint, you don't look beyond, etc. Of course, these are points of law. One can even pick them up simply from the legal side of things. But there's always the beauty, or the devil is always in the detail. And that's something you pick up only if you've been able to appear, argue, draft, and do cases in the trial courts and in the High Court, at least as an appellate lawyer, as a writ lawyer. And that, I think, feeds your role as a counsel in the Supreme Court. Look, a good counsel is a good counsel. To me, it doesn't matter where you practice. And the attributes of good advocacy in many ways are the same. How you adapt them, how you possibly escalate them is a different matter. And frankly, that is an exercise one has to do on a daily basis to have the fluidity, because situations change every day. Depends on which bench you're before, who your opponent is, what new ground has arisen, etc. So that flexibility or fluidity is anyway part of the system. But I do want to say, for those of you who are considering practicing in the Supreme Court or considering moving to the Supreme Court, please don't be intimidated. As much as I said, don't be over enamored, don't also be intimidated by it. I was, as a young counsel, I was intimidated. I used to wonder if I'd be able to have some room there. One has to chip away. There is room. Let me assure you, there is room for everyone. That room may not be the size of a football field. It may be the size of a living room. Please don't also expect the Supreme Court to let you in on a red carpet. No, it is a struggle of its own. In many ways, when I moved fully to the Supreme Court, I felt like I was back to square one in a sense. So that struggle, those uncertainties are always there. But that said, I believe there's room. If you're working hard enough, you're staying at the game, you're reading well, you're honest. Vikas had mentioned the role of senior counsel. That's a separate lecture in itself. Maybe he can call me back for that. But there's a serious role for senior counsel to perform in the court. The degree of fairness in the Supreme Court also, in some ways, I think is expected is of a different standard. But the need to be fair is the need to be fair in any court or forum that you are. And that, therefore, friends, should, in a way, give you that sense of optimism that you can make your mark there. And many counsel have, and many counsel as first-generation lawyers, non-NLU lawyers, it's important for me to say this, are shining in the Supreme Court. I don't want to make too much of a optimistic end, even because I think it's only fair that one is aware of realities. In many ways, the Supreme Court is an ocean. If I can say, the High Court is, say, swimming in a pond or a lake. In the Supreme Court, you're swimming in an ocean. Swimming in an ocean, as opposed to swimming in a lake, has its own fun. It has its own challenges. Those challenges are galore in the Supreme Court. Those challenges are galore because of the competitive nature, the many vagaries that come with inbuilt systems within the Supreme Court, within the court itself. One has to factor those in, and you will have to have a thicker skin in many ways to be able to deal with them. But that said, there's certainly room, and one must keep that in mind. But beyond that, friends, hopefully with what I've shared with you now, you've got some sense of the comparison between the practice between the two, and that will help you going forward, I hope, in some way, as counsel practicing in either or both of these courts. Thank you. Yes, Vikram, are we done? I think you're on mute. Vikas ji? Vikram, you're on mute. I'm not able to hear you. Sorry. Yeah.
So that was an intriguing session, sir. Thank you so much. I think we'll just look into the question box for a moment. I think we have 2 to 3. No, sir, we don't have any questions. Most of them have thanked you for a very insightful session. Perhaps I think Mr. Vikas, do you have any question?
Yeah. Before we take the questions, I'm just saying that a lot of people have said that why haven't you brought this speaker earlier also? Probably they've missed your earlier session. And some have written.
Sorry to interrupt you, Mr. Vikas. Sir is asking to unmute him.
Just hold on.
Yes, thank you. Yes, Vikas ji. Yes, Vikas ji, please go ahead.
I think now he is muted.
I'm so sorry that, in fact, today the YouTuber just didn't make me the host. Normally it gets the path, and I realized that I had to go to the other place. I'm saying there are a lot of messages stating therein that why haven't you brought the speaker earlier? He's such a good and profound thoughts he has given. So I can only say that we did one session with him. That was also a very unique topic, art of reading judgments. That has also been very well received, that how do you read the judgments? Now, one of the questions which has come forth is, like, you have given a lot of emphasis that you have a very little space. Like I tell my associates and other advocates, if they ask, we say it is more like a cricket that you have to be prepared to face the ball. The speed, the judge, you will have to judge in that way. So they say, how do you plan the opening statement before the court in whichever case you go? Is there any particular style, or you go with the natural flow? Not for you, for a youngster to understand.
In fact, you said space, sir. One of the things I forgot to say is the physical space also in the Supreme Court, as you know, is far tighter than in the high courts. Supreme Court is a packed court. Sometimes you have no standing room even. You may think it's a no big deal, but you're mentally in a high court, sometimes you're a little more relaxed. I returned to Bangalore today. The charm of our high court, Vikram, you know all too well. It's a, it has a added factor. Whereas in the Supreme Court, if you're getting pushed around, you have to literally sometimes elbow your way to come up front, make your point. That can also sometimes disturb your balance. But that is also, and one must factor it in. One cannot do away with it. But as to what should be the flow, look for a younger counsel. I would say, if you're appearing in an SLP as an arguing counsel yourself, there's no harm in speaking to others for their guidance on a particular case. If not, back yourself. But back yourself with that clarity that regardless of how complex or how good your case is, have your first point ready and keep that as a standalone point. You may have a backup. You may have a backup of 2 or 3 submissions, and if you're a younger counsel, in some cases, courts may give you more latitude. just out of their kindness, if I may say. The seniors don't get that. But that first point must stand on its own legs and be compelling enough objectively. And that's where I think, friends, as counsel, whether you're a senior or not, we have to have an objectivity about our cases. I say this all the time. One cannot get swayed either by what you read or what you're instructed on, or even what your instinct or your feeling for the client is. One must take that step away and look at a case objectively and say, look, what is it that really should fly with a bench? Of course, with that will come in your reading of the bench also. Benches have their own approaches. Some may be pro-conviction, some may be pro-acquittal, etc. You know all that too well. You will therefore tailor your submission depending on the case and the bench you're before. But as a rule of thumb, I would say, for all the volume of the case in the Supreme Court, your effort is to come down to that one, possibly two, or at best 3 points, which have to stand on their own legs and fit into the facts and fit into the law and show the miscarriage of justice also. As I said, you may have an excellent case on law, but the court may say it's not a case where there's been larger miscarriage of justice, SLP gone. So subconsciously, you must build that in also and look at the larger injustice that may follow if an SLP is dismissed. That would be my advice to you.
So here I have a question, sir. When you are appearing before a larger bench as an wise, what would be your advice? Because there could be parallel questions posed from the bench. So how to manage it?
That's a very important question, Vikram, because that is unique to the Supreme Court. And often cases in the Supreme Court, especially larger bench matters, are multi-counsel cases. And that is maybe a point I should have made, that in the High Court, generally you appear on your own. It's not very common in High Courts to have multiple seniors appearing in the same matter for the same side, as you know. Practices differ in courts. But generally speaking, in the High Court, you're appearing by yourself for one side, and you will have one or two opponents to reckon with. In the Supreme Court, cases, especially high-stakes cases or cases of larger public importance, are always multi-counsel cases. Now, that comes with its own challenges, because you have to then not overlap with others. Courts are very particular about that. The allocation of time you get is limited, sometimes 10 minutes, 15 minutes, even in a larger constitutional issue. And if you're slightly junior at the bar, the lesser the time you get. And you have to therefore put your ego aside, and you have to play by those rules. And you have to fit your submissions in. In fact, that is a much greater challenge, because you're now not only aware of your case, you have to be aware of the case that everyone else is building around it, and be sure that you are not repeating, not replicating, and being original when your turn comes. So that takes its own pressure. I faced that in the hijab case. When my turn came, I think I was the 7th or 8th batsman. But at that point, I was given my 20-25 minutes, and I had to make sure that what I'm saying has its own value and originality. But I think in many ways that sharpens you, and one has to be cognizant of it. Even in large commercial matters, many times you have 3 seniors on either side. And you have to be able to then work as a team. You have to be able to know your role within that team. And that learning, I think, comes with experience. Yes, sir.
There's one question by Patman Gan. She says, what is the difference between a style of argument between a 227 and 115 of the CPC of revision petition? Is there any difference of style of arguments?
No, more than, look, style has to fit the jurisdiction. It's not a question of style. The scope of a 227 and 115 are quite different, as you know. 115, after the CPC was amended, was narrowed down only to such cases where an application, had it been allowed, would have led to the disposal of a suit, right? So, for example, the rejection of an Order 7, Rule 11, or even of a 151 application which sought the closure of a suit for it having become infructuous. 115 petitions are now very restricted. And therefore, as a result, in a 115 revision petition, you have to be able to convince a court that the application was sound enough for a suit to be closed. right? Without a decree, without evidence. That's always an exceptional scenario. 227 has its own limitations. In some ways, it's broader because at least the remedy lies, it's not circumscribed, it's a constitutional right. But at the same time, Radhe Sham, etc., where the Supreme Court has said 227 is to be used sparingly, it's to be used, it's in, if I may make a comparison, 227 actually in its essence is like a 136. Your style must be to show that miscarriage of justice. That may not, Vikram is smiling because he knows that in the High Courts, 227 in many cases liberally used. But if you study the law, the judgments on 227, it's a very limited remedy. And you have to show perversity in an order coupled with miscarriage of justice. It's a power of superintendence in some way. It's not a 226 correction certiorari remedy. So if you ask me as a purist, your approach in a 227 actually should be like an SLP to say there is a miscarriage. In a 115, it's circumscribed by statute. You must fully bring your case within the scope of the application that has led to the 150. And as I give you the example in an Order 7 Rule 11, you must be crystal clear of the parameters of a 711 to justify a revision and the ultimate dismissal of a suit. There's some other question also.
Another is normally the scope of interference under the review petition before the same judge is always difficult. What type of advocacy you say that it should be chipped in?
Look, the first thing is in a review, even though you are really telling the court that there is an error apparent on the face of the record, you must do that gently because no court is going to like being told that there is an error in their judgment. Some judges are gracious, themselves acknowledge an error when it exists. And I'm reminded of one judge, Justice Shailendra Kumar, Vikram will remember, in a case where in a review, he very graciously recalled his own order because he realized he had made a mistake on law related to the scope of Section 9 of the Arbitration Act. But otherwise, courts may not always have that grace to acknowledge an error. Secondly, again, I'm taking you back to the first principles as to what is the scope of a review. A review doesn't lie just for the asking. A review is a limited window. You have to be able to show an error apparent, and you have to be able to demonstrate it from the order. It's not a rehearing of the case. You cannot go back into evidence, facts, and pleadings and have a rehearing of a matter, right? As Justice Bopana used to say, a reply should not be a replay. A review also is not a replay of the original case. It's a much, much smaller remedy. So my advice would be is to go a little soft on the error. Sometimes the error happens because of us as counsel. If you have not placed a judgment or you have not shown a particular document, I think it's only fair that you own up to it. That's the more gracious thing to do if the error is on your part. But ultimately, you have to locate it within the parameters. And friends, this is true for any case you argue before anyone, whether you argue before a revenue authority or before the Supreme Court, unless you're very, very clear on the scope of the jurisdiction that you're in, really your advocacy means nothing unless you fit it into that square.
One has asked that while drafting any petition, maybe it's a revision petition, review petition, what particular aspect should be seen as to highlight that aspect so that you are able to create that little window, what you have told, to create the space within the mind of the judge?
See, already when it came to SLPs, I said the synopsis and questions of law become very important. Now, let us say you're dealing with an RSA, a second appeal in the High Court. You must be cognizant that a second appeal, unlike a first appeal, has its own restrictions, right? A first appeal under the CPC, I think one can expect a court as a matter of right to entertain an RFA and reappreciate the evidence because that is the power vested in it. But in a second appeal, it is circumscribed by Section 100 that it shall be only upon a substantial question of law. That is true even in income tax matters. When you come up in an appeal in an income tax matter to the High Court, the appeal or a revision petition under the old Sales Tax Act, etc., they only lie on substantial questions of law. So unless you're framing those, and those are compelling enough, no amount of pleading will help. And I've always maintained pleading should be crisp and short and not run into unnecessary verbose hundreds of pages. So friends, I think that mantra would hold good in every case. If it's a review, there's no point in bringing in extraneous facts. You must be able to say simply from your first two paragraphs as to what is the error apparent that merits a review. If you can show it and link it to the order, you're home and dry. If not, no amount of pleading will help. So friends, go back to the drawing board, go back to the law, go back to the first principles, especially in drafting. And the more aware you are of the court you're before and what is the realm of that petition, the more focused your draft will become and should be.
I'm reminded they said that it was always said that brevity thy soul wit. This is how should we structure our arguments to maintain clarity and pervasiveness? Question 2, how do we handle questions or interventions from the court during our oral submissions?
Look, first question, of course, clarity. As I said, the better prepared you are, the better working note you have, the better you reflect on a case, the better the clarity, no doubt about it. There's no other way. Clarity also, friends, comes from a certain sense of security. This is very important. If you're not fully prepared, you're going to be anxious. I don't care how senior you are. If you take your job seriously, you're going to be anxious about a case. That anxiety only goes when you're prepared. There's no other shortcut, no tablet can fix it. And once that anxiety or that confusion goes, the clarity emerges from your preparation. There's nothing else. Let me be very clear. Your second question is how to respond to questions. Look, many times I've seen counsel be offended if courts are asking questions. You should not do that. Your best bet at getting relief in the court is actually responding to questions. I think I said that somewhere. If you anticipate the question of the court or you meet the question, you're home and dry. Yeah, there may be 20 points in your case, but if the court is on that one point and that question is put to you, you may call it an intervention, fine. But if you can meet it clearly, you may get the relief. And many times that happens. You would have seen it in any court. The moment you answer that doubt of the court will look to the other side and say, yes, what do you have to say? You don't even have to labor the rest of the points. So there, please don't take questions from the court as an affront. And even sometimes if a court is being slightly rough with you, try and keep your cool. Antagonizing a bench or being aggressive never helps you. It's difficult. Sometimes your opponents may throw you, but your best bet is responding. And I would frankly, I tell you, friends, you should welcome judges who ask questions. The most unsettling judges, for me at least, are the ones who ask no questions. You may have argued a case. Sometimes I've argued a case for 2 or 3 hours. There's no question from the court. I am actually concerned because I don't know what's going on in the mind of the judge. And so you find out sometimes when the judgment comes, either the hard way or if you succeed, that's a different matter. But you would wish that the court had asked those questions so you met them. So welcome those interventions, be ready for them, don't mind them, meet them to the best of your ability, but also have that skill to be able to bring the court back to the case. Many times, friends, a question may not be directly related to the matter. You must answer it, no doubt, but you must be able to bring the court back to the premise of the case. Don't let questions also derail you from the matter. That's very important.
Thank you, Aditya, for sharing your knowledge. It has always a pleasure connecting with you, though I've been bothering you time and again for a session. And before we part for the day, I had received a message that if you could speak something about the book you have written, because that's also doing extremely well, though it's not related to law as such, what it deals with, and if actually someone wants to buy, on whether it's available on Amazon or which all links it will be available.
Oh, yes, of course. I mean, firstly, thank you, Vikasji, for your perseverance and your invitation. I'm sorry I have not been able to return earlier, but it's always nice to be here. And thank you for the good work you're doing with these series. I think many, many young counsel are benefiting from it. As for my book, Poles Apart, it compares the military and democracy in India and Pakistan. It was my PhD thesis that I have improved upon and published with Penguin. it may be of interest to you, not just from a military history or a political history perspective, but possibly even from the comparative constitutionalism that the two countries have undergone. Though, frankly, that's not the focus of my book. But I do conclude that our commitment in India to the constitution early has fed our democracy. With all its flaws, it has fed our democracy. Whereas with Pakistan, the absence of a constitution and the lack of engagement with a constitutional tradition has meant that extra constitutional players like the army have usurped power, which has really eaten into the vitals of Pakistan's democracy. Even today, it's not able to recover from it. And Bangladesh is suffering the same fate. So that in gist is the book. It's readily available, I believe. And feel free to have a look at it.
Thank you. So,
Thank you very much.
Before we finish for the day, I would just like to say that with and substance of whatever Mr. Aditya Sondhi has said, he says that first you have to practice at your home that it's all the facts and law is culled out in the right manner. Then you have to be precise in your argument. And then comes the persuasive skill. I believe that all three P's, if one learns, will actually do well in the profession. Thank you, everyone. Have a great day. And tomorrow, stay connected with us to understand the nuances of Hindu Minority and Guardianship Act, 1956. Again, someone from Bangalore and who's very popular, S.R. Somashekar, a former district judge. Do stay connected with us. Everybody stay safe and stay healthy.
Thank you very much.